Good morning, good morning, good morning. Oh, Mary. Ow! Excuse me. Apparently, I spelled Tia myself. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. And, folks, Merry Stupid O'Clock to one and all, especially me, apparently, who somehow has managed to get coffee grinds in her tea. It's been that kind of morning. Now, folks, as always, at this early, it's stupid o'clock. We are going back to that horrible world known as the JRC. Before we get to it, just a few of the usual disclaimers. First off, you are going to see the link to this absolute garbage fire of a report right there in the description box, alongside the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive on the subject, the templates. Don't forget, folks, sign your name, click on your senator. Takes less than 2 minutes. It is going to work towards ending adversives and improper restraints in schools. Folks, I can't tell you how many deaths could have been prevented if we did not have this stupid crap known as adversive therapy, which is created to punish you for being disabled. Alright, so please get that done. We also have the ever present change.org Shut the Judge Rotenberg Center Down petition. Now, folks, we all know these folks are slippery bastards who, in spite of all the things that have come out about them and their school over the years, seem to somehow manage to always win on appeal and continue their abuse of disabled people. So, folks, the only real answer is we got to shut this place the hell down. So, sign the petition. Please share it on all your social media. Alright, folks, when we are talking about the JRC, you're going to hear vivid descriptions of, as well as see clips from video surveillance footage of people with disabilities being tortured and abused. If you have young children present, please use your fed phones. And, folks, as stated, it is stupid o'clock. And obviously, I am not even in my normal morning frame of mind if I'm like spilling tea all over my pants here. So, if I stumble over any of my words, please, folks, my apologies in advance, alright? Gosh, there's still coffee grinds in here. Ew. And I'm gonna burn my fingers off getting it out because OCD is OCD, and my God, howdy, is it bad in the mornings. Alright, so that being said, let's go back to where we were yesterday, which was on page 91 of this garbage fire of a report. And I think we already went over emergencies. And let me see here. Where did we leave off yesterday? Okay. Restraint supervision procedures. I don't know if we read this yesterday or not. We're just going to go with it. Just go with me. JRC's policies for the supervision of emergency restraints tracks the requirements set out by the DDS regulations on restraints. Oh my God. If you all have regulations on restraints, then those must be some of the loosest laws in all 50 states. You have regulations? Excuse me, bacon powder? What are those regulations exactly? Don't restrain non-disabled people? Because yet that's the only thing I can see here. But moving on, JRC identifies a hint of provider, HOP designee, for each shift who is responsible for reviewing a restraint and authorizing physical and or mechanical restraint for up to 2 hours. Oh my god. But that's not over long. Sometimes you need to be restrained for 2 hours. For what? Want to kick my assailant in the balls and get the hell out of there? Just saying. I'm not insinuating that all the orderlies are men, by the way. I was just making an example. After following specific guidelines for restraints, let me tell you something about restraint and autistic people, at least in regards to myself here. If you try to restrain my ass for 2 hours, I'm going to fight you. There is not going to be any calming down. I'm just going to keep going and keep going and keep going until I can get the hell away from you. Especially if I'm trying to get the hell away from you because you're trying to shock my ass. Just saying. In the event that HOP is unavailable, then an authorized staff person, ASP, who is specialty trained and authorized by the executive director, may review a restraint and authorize up to 1 additional hour of restraint. Oh my god, so your answer, oh, they're struggling. Let's add an hour. These people have zero logic. Zero logic. See, folks, this is what happens when you have a complete lack of training and have no idea what the hell you are doing. All JRC staff are trained to act as staff in attendance who understands the emotional and physical reactions to restraint and can offer support or access necessary support for a student. Bullshit. Bullshit. You're going to tell me some high school graduate with 3 weeks of training understands the emotional and physical reactions to restraint? Especially when they are non-disabled and have never been in those restraints before. Bullshit. Bullshit, Judge. What on earth are you smoking? All JRC staff are trained on positional asphyxia and how to avoid it. Oh, so nice to know that you are willing to figure out how not to kill us by lack of oxygen. How nice of you to, make sure I don't choke to death. But, don't care so much if I am harmed horrifically by shocking me. Stellar. Limitations and release of emergency restraint. Restraints may not be applied for a continuous period exceeding 6 hours. Oh my God, Judge. Your complete lack of understanding of mental health and developmental disabilities is so telling throughout the entirety of this report. It's sad. This judge had no business being 6 foot within this incident. I'm just saying, you needed a judge that specialized in this kind of law. I don't think Isaac Bernstein did, or if he did, it was in the fucking 30s. Restraints should not exceed any period over 15 to 30 minutes. Okay? Really? Really? And a good majority of the time, folks, you don't even need the damn restraints. If you treat us with some humanity and like we have rights, maybe we wouldn't act out all the damn time. Just saying. For a mechanical restraint, the use of such restraint on a non-continuous basis cannot exceed 8 hours in a designated 24-hour period in conjunction with typical JRC school day. What the fuck? As I said, this judge has no business being anywhere fucking near mental health or developmentally disabled law or this incident if he thinks any of this is accurate. My God. This is what happened when you have untrained individuals making policy decisions for a vulnerable population, and the judge just goes with it because they're the experts. If an individual is in restraint during this transition or has experienced a significant amount of time in restraint that evening, staff must communicate this to the next shift or in the log so that the time period can carry over to the next period. Oh, for the love of God. Temporary relief periods, or at least 10 minutes every 2 hours of restraint, must be provided, except when there is an obvious and substantial risk of harm. Oh, Jesus Christ. If you haven't managed to calm us down in 15 to 30 minutes, think about it. Good Lord. But you could actually hurt us. I don't know. Maybe stop shocking us, depriving us of food and sleep. Then maybe, possibly, there wouldn't need to be any need for restraint. Just saying. These checks should be noted on the restraint form by the SIA. Provision must be made for reasonable access to drinking water and bathrooms. Reasonable. You call having to wear those goddamn electrodes to the bathroom and being under threat reasonable. Restraints must be checked every 15 minutes for comfort, body alignment, and circulation by SIA. Oh, for the love of God. What on earth makes you think that restraints are ever comfortable? What crack are you on? Notation of such checks must be entered on the special restraint form. An individual must be released from emergency restraint no later than the expiration of the order for the restraint. Prior to the expiration of the order for restraint, when the restraint is no longer necessary to prevent the continuation of the emergency. Relaxation of hold to determine if restraint is needed to prevent continuation of the emergency is not considered to be a permanent release, or if he or she is asleep. Jesus, what is wrong with these people? Did you ever think that those behaviors that you people think require restraints are actually being provoked by the people at the school, judge? Remember, it is in their own policy to provoke behaviors from the students to then punish and correct them. Okay? So say one gets fight or flight real bad. So it is then okay to hold them in restraints for up to 2 hours, possibly even longer, for a behavior that the fucking staff provoked? Think on it. A doctor must see minors within 15 minutes of the initial order. Oh, you mean the on-call doctors that work for the JRC? Yeah. If a doctor is unavailable, then a registered nurse, nurse practitioner, or certified physician's assistant must see the minor in the first 15 minutes. A doctor must then see the minor within the first hour. If the restraint exceeds 1 hour with any 24-hour period, the HOP must review the use and a report must be submitted explaining the need for restraint. Okay, so this morning's episode was rather loaded. So before we close out, let's think about this a moment. This judge is justifying a restraint hold on an individual for 2 hours, 8 hours, even longer if the JRC can find a shield to write on a piece of paper to justify it. The judge also never states, almost like it never happens, that during the time they are in restraints, more often than not, these kids are being shocked the entire time. So, guess what happens when you're in shock? Muscle tense ups. And what does the JRC write off muscle tense ups and screaming as? Aggressive behavior, which then allows them to keep them longer on the 4-point board and other restraints. People like this judge have no business reviewing a place like the JRC. They have zero experience in the mental health field, zero experience in the developmental disabilities field, zero experience in the neurodiversity field. If you're going to have an independent, non biased observer do a report like this due to the incident of August 26, 2007, get somebody that is outside of Massachusetts who specializes in this kinds of law and has a decent background doing mental health and developmental disability cases. Because obviously, we can't find a doctor in this entire damn state, nor a judge, that is going to have a non biased opinion. Granted, this is coming out of the JRC's own pocket. Remember, they said that they hired Judge Isaac Bernstein to do this report. So perhaps we shouldn't be so surprised that he's such a shill. And on those thoughts, we're going to go ahead and close out for this morning. We don't get very many views on this channel. The few that we do tend to get removed from time to time. So folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. Please feed that algorithm. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. Bye-bye.